Good afternoon, and welcome to the Labor and Employment Practice Group session for the 2011 National Lawyers Convention. Our topic today is organized labor and the Obama administration. As usual, the Federalist Society has assembled a distinguished panel of experts to discuss this topic. The percentage of private sector employees who belong to a union has declined, as we all know, although more government workers are joining unions. Some political leaders are raising new questions about whether government employees should be allowed to bargain over wages and benefits. Since 2010 midterm elections, prospects for pro-labor legislation have faded, but with the White House gearing up for a new presidential campaign, perhaps continued strong and active support by organized labor for the Obama administration is more critical than ever before. This panel will explore how organized labor's political agenda has influenced and will continue to influence the Obama administration's regulations and policies with a focus on labor and employment laws. The panel will explore whether current initiatives and federal regulatory agencies have supported organized labor, including decisions and rulemaking at the National Labor Relations Board. The panel will also explore the administration's opposition to state right-to-work initiatives and limitations on public sector unions, including the impact that such initiatives could have on campaign finance. Finally, the panel will discuss how the Obama administration may continue to support organized labor's agenda or not over the next 2 years. Our first panelist on this topic is Eugene Scalia, a partner in the Washington, D.C. office of Gibson, Dunn, and Crutcher, and a member of the firm's executive committee. He is co-chair of the firm's Labor and Employment Practice Group, chair of its Administrative Law and Regulatory Practice Group, and a member of the firm's Appellate and Constitutional Law Practice. He previously served as the Solicitor of the United States Department of Labor, the department's principal legal officer with responsibility for all department litigation. He graduated cum laude from the University of Chicago Law School, where he was editor-in-chief of the Law Review. From 1992 to 1993, he served as a special assistant to Attorney General Bill Barr, and where he received the Department of Justice's Edmund J. Randolph Award. He graduated with distinction from the University of Virginia in 1985 and was a speechwriter to Secretary of Education Bill Bennett before attending law school. He has been a lecturer in labor and employment law at the University of Chicago Law School. Our next speaker will be John Raudabaugh of Nixon Peabody LP, and is a former member of the National Labor Relations Board from 1990 to 1993. He is an experienced labor and employee relations law counsel serving multinational corporations in policy, litigation, and regulatory compliance and counseling. John authors frequent alerts regarding critical developments in labor and employment law entitled Inside the Beltway. He served as an adjunct professor of labor law at Northwestern, at the University of Chicago, and at the Emory University Law School. In 2009, he represented U.S. employers at the International Labor Conference 98th session and served on the Committee of the Whole addressing the global job crisis. He earned a law degree from the University of Virginia, a master's degree from Cornell University School of Industrial and Labor Relations, and a bachelor's degree from the University of Pennsylvania Wharton School. And our final speaker is Bill Samuel. Bill is the Director of Government Affairs at the AFL-CIO. In addition to serving as the chief lobbyist for the 9 million member Labor Federation, Mr. Samuel chairs the AFL-CIO's Legislative Committee, which is made up of legislative representatives from the Federation's 66 affiliated unions. Mr. Samuel returned to the labor movement in January 2001 after a 5-year stint in the Clinton administration, where he served first as Associate Deputy Secretary of Labor under Robert Reich and then Alexis Herman. In 2000, Mr. Samuel joined the White House staff as senior policy advisor to then Vice President Al Gore, and served as the Vice President's principal advisor on labor policy issues and liaison to organized labor. From 1984 to 1985, Mr. Samuel was the chief lobbyist at the United Mine Workers of America. While at the UMW, Mr. Samuel led the successful campaign to win passage of federal legislation guaranteeing lifetime health benefits to over 200,000 retired miners and their dependents. He is a graduate of Oberlin College and the George Washington University Law Center. Our first speakers, Mr. Scalia and Mr. Raudabaugh, will speak for approximately 12 minutes. We're going to give Mr. Samuel, because he's handling two at once, maybe a little more time, and give them an opportunity maybe to discuss this topic among themselves before we open it up for questions. So without further ado, Mr. Scalia, if you will join us.
Thank you, Judge, and thanks for moderating this program today, and thanks to all of you for joining us. And I want to thank Bill as well for joining us. It's not always easy to be the AFL representative in a Federal Society meeting, but these events don't work without people such as Bill agreeing to be here and participate in a constructive and civil debate. So thank you, Bill. And
I have to be civil.
We do, you don't. But I urge everybody to be, and in fact, I'm feeling so civil toward Bill today that I'm ready to predict now that I'm going to agree with you on more than we disagree in the course of this afternoon. I'm willing to bet. So I thought I'd speak relatively briefly and set the stage for our discussion this afternoon with just some fairly general observations about the Obama administration labor movement. The overarching one, I think, would be that the current administration is attempting to do a number of things that are greatly alarming to American business, and yet has not achieved enough to satisfy organized labor. So you have a dynamic where business is quite alarmed, and I think justifiably so, and yet organized labor takes a look at the record of accomplishment and says, what have you done for us lately? Behind this are a couple facts. One, that organized labor is not succeeding these days at that thing for which it exists, and that is to serve the workplace representational interest of private sector workers, which now only 6.9% of private sector workers are represented by labor unions. That's down from about 21% in 1978, and if you go further back, say to the 60s, that private sector number was even higher. It's been on a steadily downward trend for a long period of time, which naturally is a subject that the labor movement very eagerly wants to address and reverse. Even while failing at private sector workplace representation of workers, however, labor unions have, I think, to some extent succeeded beyond anybody's dreams in another area, and that is in the area of influencing American elections. So in the 2008 election, the labor movement contributed, that is, through independent expenditures and the like, an estimated $450 million to the presidential and congressional elections. In the 2010 midterm elections, 3 unions alone were estimated to have spent approximately $170 million. That's on the midterms. Labor unions are the single largest group contributing and, again, engaging in expenditures in connection with American elections. Some unions spend up to 20% of the dues they receive on election activity and on lobbying. So that's been, when you talk about this dynamic where what the labor unions are looking for is an expansion of their private sector representation, and what the Democratic Party is looking for is election support from the labor unions. That's been the contribution on the labor union side, together, of course, with a great deal of assistance on the ground game, getting out the vote, and all the kinds of ground game activities that are so important in the weeks and days leading up to the election. So when the labor unions look to the administration and say, here's what we contributed to you, what have you achieved for us, the big play during this administration was, of course, the Employee Free Choice Act. The Obama administration did support that. The President certainly spoke on it, the Vice President as well. They purported to push for it. I think Mr. Samuels will say that they did not do enough, but certainly the administration did enough to indicate that it supported it, backed it, that it was an Obama administration initiative. And I think that hurt the administration because the Employee Free Choice Act had a couple of very significant flaws as a political matter. First, it was immensely alarming to the American business community because it would have greatly enhanced unions' ability to get workplace representation in a way that the business community regarded as unfair, as an ambush election. And the second flaw was, I think that the American people as well just saw it as unfair, that to have a proper and legitimate election, there ought to be a secret ballot, and there ought to be some sort of a campaign period in advance where both sides of that debate could be heard. And the Employee Free Choice Act stood in the way of that, and that was not accidental. It was really intended, I believe, to avoid the advocacy on both sides of an issue that's the hallmark of a fair election, as well, of course, it sought to avoid the privacy in voting that is the purpose of the secret ballot election. The other flaw legally with the Employee Free Choice Act was the interest arbitration provision, which was also controversial. It never rose to the level of controversy as the card check provision, but also was a serious flaw. So that was a major fight at the beginning of this administration. The administration lost, organized labor lost. The administration lost both in the sense that the act did not pass, but also that the business community, I think, was legitimately alarmed by the prospect of such legislation. Bill can speak to this more, but I think that organized labor may feel that the administration could have done more and failed to in championing that law. I'm going to restrict my remarks largely to things involving the labor movement outside of the National Labor Relations Board and the traditional labor law context. But let me just touch briefly on a couple of current initiatives that I think are reflective of the relationship now between organized labor and the administration. Those are the quickie election, or what I call the blitz election rule proposed by the National Labor Relations Board, which I suppose theoretically could be, there could be an attempt to finalize it in the next couple of months, and also the so-called persuader rule, which has been put forward, proposed by the Department of Labor. And these were proposed at almost exactly the same time. And my own assessment is that they are two rules intended to work together, in a sense, in lieu of the Employee Free Choice Act, which failed, and as an alternative means of enabling unions to quickly conduct elections in which employers have very little opportunity to mount their own views, let the employees know how they view the prospect of unionization, the costs it might impose, and the like. These have drawn less attention. They don't require a vote, obviously, in the House and Senate. The President, I suppose, has a bit more distance from them as well, because he doesn't, at the end of the day, need to sign legislation that, as he would in the Employee Free Choice Act context. But these also are initiatives that are alarming to the business community because they see it as an ambush, that once again, you'd have a situation where within as few as 10 days, an employer would have to be appearing before an officer of the National Labor Relations Board addressing such questions as the proper definition of the unit and the like, whereas many American employers don't even have a labor lawyer in their Rolodex, don't know one. The union may have been working, attempting to organize that workplace for weeks or even months. The employer has just days to respond. That's of concern to the business community. Whether these rules are finalized remains to be seen. Let me move then from that area to other areas where I don't know how strongly the labor unions may have felt about certain other initiatives, but certainly they were important in the business community and perceived by the business community as initiatives that would be harmful to their interests and that were intended in one way or another to strengthen the leverage of labor unions. One that received relatively little notice was the so-called Disclose Act, which was legislation introduced in 2010 in response, supposedly, to the Supreme Court's Citizens United decision. That, of course, was the decision finding a constitutional right on the part of corporations and on the part of labor unions to make independent expenditures, that is, run campaign ads, in support of political candidates. It's the decision that President Obama criticized at the State of the Union address in a somewhat famous incident. So this bill was introduced in a couple months after that, purportedly to reverse the Citizens United decision, or rather to limit corporations' ability to influence elections within the constitutional parameters set down in Citizens United. But upon analysis, what became clear was going on in the Disclose Act was that it was an attempt to have Citizens United in part, but not in full. It was to enable that part of Citizens United which gave unions a large role in elections to take effect, but to find other ways to discourage corporate political activity. It took advantage, for example, of the fact that unions receive their funds through relatively small individual donations and said that certain very, very small donations don't have to be disclosed. Corporations, on the other hand, fund business associations through larger contributions, albeit from fewer corporations. Those larger contributions did have to be disclosed, and indeed a corporation that funded an association that in turn ran an advertisement could have found under the Disclose Act that its CEO would have to appear on television and take ownership and responsibility for a television ad run by the business association, even if the CEO had no interest in the election, didn't fund the ad, didn't ask for it, and didn't really even care. Under the Disclose Act, that man or woman would have had to get on TV and say, in essence, this is my message, I support it. That was obviously of concern to the business community, which wants to fund business associations, but does not want to be forced, for example, to appear on television supporting campaign advertisements that may not even have been advertisements they intended to fund. The Disclose Act ended up losing in a filibuster. It lost Democratic support as well as Republican, in part because of backdoor deals that were made to attempt to win some Republican support. There was a deal to carve out the National Rifle Association so that their members could be excluded from the disclose requirement. That was felt needed to get certain votes, but that in turn angered some of the Democratic caucus. It was not a pretty moment, I think, for the Democratic caucus, nor for the administration. And again, it was an alarm bell for the business community, which felt that there was an attempt to prevent it from exercising its ability and right to participate in the political process, even as unions would have been able to continue and go forward participating. The last area of interaction between this administration and labor unions I thought I would touch on to set the stage for discussion is one that really doesn't catch the attention of labor lawyers, but is quite important to the labor movement, and that is labor union shareholder activism. And the single most important element of which over the last couple of years has been something known as proxy access. Proxy access is the notion that certain large shareholders should be entitled to use the company's proxy materials in order to put forth candidates for director positions rather than having to run a proxy contest. The theory has been a proxy contest is too expensive. It ought to be easier for shareholders to put forward their own candidates for director rather than the company only putting forward its candidates in the proxy. Therefore, let's open that proxy up, make it a sort of joint ballot. This was a rule proposed by the Securities and Exchange Commission back in, I think it was in about January 2009, or I'm sorry, January 2010, finalized in about August 2010, and ultimately challenged by the Business Roundtable and the Chamber of Commerce in the D.C. Circuit in a case that I handled. That rule had been vigorously championed by the labor movement because labor funds, that is, multi-employer labor funds as well as government pension funds are among the most active shareholders in public companies. And I think you could say in some ways that labor unions affect private corporations in the U.S. now more frequently through their shareholder activism than through their on-site representational interests. We found that of shareholder proposals submitted to corporations in 2007, something approximating 400 of 700 that were received by U.S. corporations had been submitted by either jointly managed union management funds or by state pension funds. A recent study, I think done by the Manhattan Institute, found that when it came to proposals to somehow restrict corporate spending on political activities, 45% of the shareholder proposals received by corporations in that area had been submitted by labor union funds, which of course is a bit ironic given how extensively the labor unions themselves are involved in political activity. Those proposals are an attempt to prevent corporations from engaging in the same political speech that the labor unions are. So the proxy access rule would have permitted this sort of access to the company proxy on the part of the labor union pension funds. It was challenged in the D.C. Circuit on several grounds, but among the grounds that we challenged the rule was that the SEC had given insufficient attention to the divergence of interest that existed between union shareholders and your typical shareholders, that labor unions in some circumstances would have alternative agendas they would attempt to achieve through a proxy contest or a contested election that would disserve the interests of shareholders generally, even while they might advance the interests of the labor union. The SEC had largely disregarded the evidence of that in the record. The D.C. Circuit, in a decision that I think will have implications for other Dodd-Frank rulemakings, held that in doing so, the SEC had violated both the Administrative Procedure Act and also a particular provision of the Securities Exchange Act requiring consideration of effects on the economy, efficiency, and capital formation. So that was another, I think, important initiative for the labor movement that although the SEC undertook to provide what was sought by the labor movement, it failed in the courts, and it's unclear whether the SEC will attempt to go forward. Let me just touch finally on 2010. Because there's actually been, I think, in some ways, a development in the last couple of years that dwarfs even EFCA in the debate about the role of labor unions in the country, and that's been the sudden focus on the role of state and local government unions, and that peculiar relationship that exists whereby unions invest time and effort to elect certain candidates who then take the other side of the bargaining table and are suddenly responsible for attempting to strike a fair deal with the workers from whom the union will then seek checkoff and use that money again to support those very same workers. Rather than bargaining against one another, often there's an interest on the part of both the now elected politicians and the labor unions representing the workers, an interest on the part of side of both to inflate wages and benefits in a way that I think the American public has come to recognize. Now, the Ohio law was repealed. That law has been changed, but I think this is a debate we'll continue to see going forward. And I think in some ways will be of even greater concern to the labor movement because, as Judge Pryor mentioned, the government unions now account for more than half of union membership, and therefore, when you look at the political expenditures that labor unions make, you have to figure that more than half of them are coming from the dues that are paid by government union members. And if the labor movement is unable to stem what I think remains growing public concern with the role of public sector unions, then I think unions' ability to influence election outcomes may itself begin to diminish in a way that their influence upon the private sector workplace has begun to wane. So, thank you.
Good afternoon. I want to say that after serving on the National Labor Relations Board, unfortunately, the rest of my life I have been nothing but an NLRB geek, and Several of my closest friends are also, and so knowing what goes on in the rest of the world is very difficult, but I would like to proceed with talking about the board. I think at this point, the whole process, the statute and the agency, unfortunately, through many, many, many variables, it has been reduced down to something very close to a meaninglessness, an embarrassment. I would like to suggest that among my close nerd friends, we have a very long list of new names for NLRB. Mine is no longer a reasoned, rational, or relevant board. And I feel very strongly about that. I also don't understand anymore how we can have deference to the agency's expertise when we have flip-flopping. I mean, it's an embarrassment to read the rationale to put into place something that was reversed previously, and so forth and so on. We can do better. We have to do better. In the most recent press release, the board was quite proud to talk about productivity up for fiscal year 2011. They issued 368 decisions, an increase of 17% over the prior fiscal year, but it was down 52% relative to fiscal year 2001 and 65% relative to fiscal year 1991. And the backlog is still high. The budget of $282.8 million is 183% greater than the budget in 1991. And we still maintain 51 offices in addition to the lovely headquarters bastion. Ever since the former chairman brought in a very nice person to run the Office of Public Affairs and engage in enriched outreach and public information, there have been 181 press releases, 70 of which concern institutional developments. 99 or 90% of the remainder deal with the union one here. The employer was accused of outrageous unfair labor practices and so forth. And yet all the decisions are publicly available. We are making a mockery of any suggestion that the process is related to the rule of law. In the rulemaking, as we're all quite familiar, we have a notice of employee rights, which in my opinion is no big deal. Anybody who's a labor lawyer and has been to every one of the cafeterias where the amalgam of a gazillion notices is posted and everybody walks right beyond it, no big deal. What is the big deal, however, is there's no statutory authority for it, and it violates employers' First Amendment rights by forcing speech, whereas in every other example of a federal statute requiring a notice posting, it's specific language in the statute. This is an embarrassment that people who went to law school and are sitting on the board or in the general counsel position would engage in this kind of activity, in my humble opinion. Then we have the notice of proposed rulemaking that would shorten time for the critical period of an election, defer hearings, compromise due process rights of parties, all to speed it up and accomplish what Hefner was attempting to do, which is what the academe, that means people who didn't go to law firms but instead stayed and practiced teaching, have refused to acknowledge the Taft-Hartley Act of 1947, the existence of Section 8C, and they maintain, and I've seen it 100 times, 1,000 times in articles, moving from the 1930s forward, that the statute encourages collective bargaining. It's in the preamble. Therefore, by definition, it necessarily follows. Collective bargaining requires a union and an employer to bargain. Well, you can't bargain with the union if it doesn't exist. Therefore, we have to encourage representation. That was what it was in 1935. Then we had 1947. And I would submit to you, after 76 years, it's time for a massive overhaul that I'll address at my conclusion. Well, look at the case developments just in the last year and a half. We've had the incredible extension of Lafayette Park and Lutheran Heritage to be used in a manner to review the nuances of every employment policy in any employee handbook to find that it might chill the exercise of concerted activity and employee rights under the statute. I think that's wonderful. That's wonderful. Articulate the standards, and then anyone who has a master's degree in quantitative statistics can do correlation analysis, and it's quite interesting to see, depending on the majority of the board, how these cases come out. There's an enormous correlation in manipulating, in my view, the standards to have an outcome that is pro-union during one era, pro-company during another. This is expertise? No. Well, then we have a series of flip-flops. We have Lamont's gasket that reversed Dana on the voluntary recognition and the posting of the notice for 45 days. Then we have the flip-flopping on the successor bar doctrine. UGL Unico reversed MV Transportation, which returned to St. Elizabeth Manor. This is expertise. If it were expertise, then what came out the first time should have been recognition of the field of all of us experts that this is the standard. But we know that's a joke. Then we get to Elias and Newth, for the first time in 76 years, finding that when you have an inflatable rat the size of this entire room vertically going up in front of someone's entrance, that is not the equivalent of picketing, and therefore we shall treat it as different and unique. And now we have removed these gigantous things from any illegal secondary activity. Oh, genius, actually, yes. Okay. Then we get to J. Pickney Flooring, where we start into this whole area of use of the employer's electronic computer systems and so forth, which is a very interesting, complex issue. And I defer, oftentimes, I found it's very helpful to talk to IT people. I always defer initially and say, please, I have some questions, but I do feel I need to make an admission. I was born before Bill Gates, so be tolerant. Then we have the case that is very troubling to me, Parexel International, where the board found that the discharge of an employee who had not yet engaged in any protected activity but might complain in the future was unlawful. Maybe some of those California regulations already apply here, I don't know. Next, the AT&T Connecticut, we justified a union t-shirt that said inmate number on the front of it, and this is for like a Comcast or Verizon person to come to somebody's door. Now, can you imagine if they came to some elderly person's door and they're standing there with prison number or inmate number? Oh, that's okay. That's the expertise of the agency. Then we have some very interesting issues that I think deserve contemplation and study. And literal expertise, and that is access to private property. I can remember a very famous case coming out. It was Justice Thomas's first decision. And I was a board member. And the chairman of the board was furious with the decision. And I was new, and I was from Atlanta at the time. And I had a tendency over my life to adjust through just hearing people speak to sort of the accent of where I am. And Mr. Stevens was furious and couldn't understand why Justice Thomas would rule in favor of property rights. And I looked at him right in the eye and I said, well, Jim, down in Georgia, when the sign says no trespassing, it means what it says. But here we are again, contemplating very complicated property rights of access to, for example, a massive shopping center by off-duty employees of a restaurant lessee of the shopping center to engage in union organizing. These are interesting questions. That's one that's very important. Then we had specialty health care come out based on a sort of a flag by Member Becker a year earlier. The one thing I learned as a board member is the issue of appropriate unit design is the most fundamentally important issue that any employer can ever face. And it's very difficult for me as a labor lawyer to apparently communicate that effectively to people called clients, but I will tell you it's critical. And specialty health care came out and essentially said, whatever the union comes forward with is essentially, presumptively, the unit. So as Member Becker found, and with parents who were from the Midwest and never drank and never went to gambling places, I've never been either, but that case, Becker said something like one type of, apparently there's lots of different types of dealers with different types of gambling games, and so if you were a dealer with this type of gambling game, you could organize into your unit, and just because there were dealers in other games, they didn't have to be part of the dealer unit. This is where we're headed to help unions get in the door. That's fine, but we're not allowing now employers to justify several things. One is the organizational structure to enhance their productivity, which is invariably competitive, value-added information that distinguishes Casino A from Casino B. And yet we're going to ignore all of that design simply to allow unions to hatch. I find that very disturbing. Then Allied Mechanical, a case that just came out, and we applied BE and K for the first time to my knowledge to find that an employer's lawsuit against a union was in fact an unfair labor practice and filed for a retaliatory purpose despite First Amendment rights and the standards in BE and K. Two very important pending cases, Roundy's, again, access to private property. Then we have D.R. Horton over the issue of whether you can require as becoming an employee the waiver of rights to class arbitration. Then we have the acting general counsel who was on my staff, Leif Solomon, and we have an endless page of activities, which I know the time is running, but nip in the bud is simply a good character for him. He wants to nip in the bud anything that might sprout. Therefore, if you can think of anything, it will necessarily be litigated. He has issued memoranda to identify the issues. He is expanding his use of 10J authority, and of course, just 2 days ago, the board announced what? We're essentially going to be down to 2 members. We now delegate to the General Counsel all of our approval under the Act relative to litigation and certification of representation elections. So now we have an acting General Counsel prosecutor who has ramped up enforcement, and I approve of that, frankly. Fine, go for it. And remember, Senator Reid, you taught the Republicans all about how to shut down the nomination process. So now, Leif, you're going to teach some future Republican acting general counsel to do the same. But he's charging ahead. He's got a very lengthy agenda, including captive audience, equal time for captive audiences, first contract bargaining expenses, supervisory status, again of charge nurses, use of employer email, partial lockouts, and most interestingly, finding the use of economic strike replacements to be unlawful if he can find animus or an unlawful motive. Do you think he'll find it? All right. Then we've got the Boeing case. And as I said in my alert, do you think it will fly? Or land? I'm not going to get into the theory on that. That has upset everyone. It has been something that I've never really witnessed in my career as a labor lawyer, and has brought a lot of attention, for which I'm quite happy, as I'll conclude. And then I would just like to note that there are over 40 bills pending in Congress right now to propose amendments to the National Labor Relations Act, some of them to counter the Boeing mishap, some of them to ensure secret ballot elections, some to counter the notice posting, some to counter the pending rule to deprive employers of any due process, to deprive employees of hearing a different perspective on the pending election from, yes, their employer. We also have pending amendments, one from, I don't know if you'll guess the party, but to delete 14B from the statute. That would be the Democrat Party. And then we have the Hatch bill, which I am personally supportive of. It was prepared prior to some of the attachments here in September to counter some of the board problems, but it is a systemic overhaul of the statute for some very important reasons, and I encourage you to read S-1507 or House Bill 2978. And now I'd just like to conclude briefly, and I brought some copies of a law review article that will be issuing apparently in 2012, January, but they're there for your reading. I feel that we're all trustees. We're all trustees of our communities and of our world. And it's it's a heartfelt obligation to say that we need to think about whether or not in the workplace, much less in our civic lives, whether everything should be reduced to, as I like to remember the president for whom I worked, that's good, or that's bad. Is everything liberal or conservative, Republican, Democrat, up, down, yes, no, right, wrong? And I would like to suggest that we have to come up with alternatives. I'm not suggesting the statute be shelved or discarded, but I make some recommendations, one of which is, yes, going back to the whole purpose of my electromation decision, we've got to get rid of 8A2. We have got to allow employees who would like to be represented by a union in the traditional sense and defer their individual voice to a representative who's going to speak for them. And they'll get to evaluate whether that's good or bad. But I have news for you. Everyone I know would like to have an opportunity to sit down with their employer and talk about issues called subjects of bargaining. And you know what? No, I don't need to pay you to speak for me. I choose not to. And to suggest that 90 3% of the private sector workforce are anti-union is wrong. By their own studies, they suggest that 54% or something like that, one of the academics, want unions. Fine, go for it. Well, take 100 and subtract 54, and the difference, they don't want unions, but they aren't in the position of being able to discuss issues affecting them in the workplace. How preposterous. How Neanderthal. And we have the other issues. Basic issues of respect for, do I have a vote on whether we're going to strike or not? Even if I'm not a full dues-paying member, but the strike is called and I have to honor it, and so forth and so on. So these issues that I lay out here, I urge us to consider. This isn't about how horrid unions are or how much I would love to develop a comparable piece to the map you have on the web page where you can click on any zip code or type in a company name and find out how nasty and mean they are because of all of the violations under the Department of Labor and other places. I don't see one yet that says click on a zip code for a local union or the international union to find out all of those violations and criminal violations and so forth. So I'm not suggesting we go down that route. I'm simply saying we have to move beyond this kind of control over intelligent fellow citizens, neighbors, and friends, and allow another option. Thank you so much.
I won't take long. Thank you very much for inviting me. I guess this is what's known as a target-rich environment coming third. But let me. I'll try to keep it brief. I really do thank you for having me here. This is. It can be discouraging these days representing organized labor. As was pointed out, we're now representing less than 8% of the private sector, about 12% of the overall workforce. Union density is as low as it was. It actually has not been this low since before the Wagner Act, 1935. We have some of the weakest labor laws among the Western democracies, and in fact the lowest union density in almost the entire developed world. So it can be discouraging, but when I come to events like this and hear how the labor movement is just this close to destroying the capitalist system, I feel a little bit, like maybe we're fighting above our weight class, maybe we're getting somewhere. So thank you. The Obama administration, actually, I think Mr. Scalia described our views of it appropriately. Obviously, we all woke up November 4th, 2008 with very high expectations. The Employee Free Choice Act was just one of the things we thought we would accomplish after many years. And we've been disappointed, not so much in President Obama. I think he's tried. He's got, obviously, being President of the United States in this era. Foreign policy challenges, domestic economic and global economic problems is not easy with a hostile Congress. Our disappointment really is in just the situation we find ourselves in, not so much in him. I will say about the President, though, and I've been around him a little bit and certainly around his staff quite a bit and seen him speak, he really does get collective bargaining, and I think everybody in this room supports collective bargaining. Certainly former Speaker who was on the NLRB supports collective bargaining. President Obama really, he intellectually and sort of innately understands the role of collective bargaining in a free society, in a free market economy, in a democracy. I've heard him talk about it in ways that are very convincing. And I think he's as worried as we are that the number of workers covered by a collective bargaining agreement is as small as it is. We look back on the last, in the post-war era, about, I guess, almost 70 years now, 65 years, in this way. We had a tremendous period of growth in this country in the late 40s, 50s, and 60s, about 2.5 decades. Profits were going up, productivity was going up, and lo and behold, so were wages. And in fact, we had a pretty healthy income distribution as a result of collective bargaining. I mean, a lot of academics will cite the fact that 30% of the workforce was covered by bargaining, but they were bargaining for other people as well. Obviously, with that level of density, other employers were looking over their shoulder and trying to remain competitive on wages. So everybody was sort of benefiting together. It was all, the tide was lifting all boats. And in fact, wage growth at some of the lower income levels was higher than at the top income level. Now, in the 1970s, really, it began to change. Profits and productivity, I wish I had a graph, profits and productivity continued upward, and you can see it on a graph very clearly, and wages began to flatten out. We think a lot of this has to do with what was happening in the 1970s and has continued to happen and, in fact, accelerate, which is the decline in the number of workers who could bargain for better wages, who could sit across the table from an employer and try to get some basic fair agreement about how much of the profits would go to workers, what kind of benefits would be available. So those lines diverge, and if you look at them now, you'll see that profits and productivity, with obviously, there are years when it's not a straight trend, but profits and productivity continue now. We certainly know that Wall Street is back to making a bundle. Banks are making money, but we still have this sort of flatlining wage situation. And collective bargaining is not the only reason. I'm not going to try to convince you it is. We have globalization. We have, to some extent, immigration. There are other reasons that we have wage pressure has been keeping wages down. But we really do believe, and I think the President believes, to go back to my earlier comment, and a lot of academics, economists, even Ben Bernanke has said this, a good, healthy share of it is due to the fact that collective bargaining is disappearing in this country. And we should all be worried about that if we want to have a country where we have a reasonably fair distribution of wealth. I think if you go out and talk to the folks at Occupy Wall Street, folks in Ohio, there is a sense that something's wrong, that the country is, somehow we're off on this wrong path. And I've heard folks write about the U.S. looking at the economic system, and we're now looking more and more like a banana republic, where more and more of the income is concentrated at higher levels. We have less income mobility than Western Europe now. We used to pride ourselves on this idea that, well, if you're born in America, you can be anybody, you can meet any challenge. In fact, that's declining because one reason education is becoming out of reach for so many Americans. So anyway, we worry about this. I don't know how, whether the Federalist Society and folks here just see the world differently, or you would apply different solutions. But I think the world I'm describing, I think, is pretty accurate. Now, so one of our big concerns about the decline in collective bargaining is why we got here and why we are staying here is because employers have all the cards. They really do have all the cards. I mean, I love to hear about how unions are going to, if we pass the Employee Free Choice Act, you better look out, small business, because we're coming at you. It is, given the state of the law and the opportunities employers have to keep employees from organizing, it's ludicrous to think that we present that big a threat. And I think, we've cited these statistics for years. In 25% of the organizing campaigns, an organizer is fired. In 89% of the cases, the employer holds a captive audience meeting, at least one captive audience meeting. In 66% of organizing campaigns, supervisors hold one-on-one weekly meetings with their employees to educate them about what it would mean for the union to win, for that person to vote for the union. Now, that is obviously a very difficult situation to overcome if you're a worker, particularly a worker in an economy with high unemployment. Who's going to take on that chance when you've got to take a paycheck home to your family? That your decision to join a union could mean the end of your job. And too often it is. So this idea that somehow we've got this level playing field and anything we propose to maybe to streamline elections or increase penalties, which are essentially non-existent, is somehow going to upset the balance of power that exists. The balance of power that exists right now is all in the employer's favor, and it has been for many years. So back to the economy. If we're going to fix the economy in a way where income is distributed relatively fairly, we're going to have to give workers a little bit of power back, and that's going to mean the right to bargain collectively with their employer, because we have seen periods of growth, as I said. We're seeing a period, we saw a period in the 1990s of very fast growth, but wages didn't really grow very fast along with it. And one of the reasons is because workers don't have the ability to demand their fair share. Now, as far as the NLRB, you know, we in some ways we see it the same way. It is broken. I mean, it is a badly broken agency. Of course, I think we would maybe see it broken for different reasons. The Boeing case is probably a pretty good example. I mean, to me, it's maybe an indication of how weak the remedies are and how little employers even think about the NLRB, that a Boeing executive would so obviously and blatantly break the law by going on television and saying, we're going to move our production because the workers in Washington have gone on strike too often. Well, that really is, that is a statement meant to discourage workers from striking. It can't be read any other way, but I think he didn't even think that there was a problem doing that because the board is so toothless now. There's no, and the only remedy, of course, you have for that is to try to restore that work if the violation is upheld. So what did the board do? They filed a complaint that that statement was evidence of retaliation for the lawful exercise of rights. It was a pretty routine case, actually. What made it not so routine, of course, was it's a big company and they sunk $1 billion into a plant in South Carolina while the case was proceeding. Now, there is a doctrine of undue harm, or undue hardship, I guess, and I don't think it's too likely that the board, if they find Boeing guilty, is going to make them move that work back. They're going to find some other solution to try to make the workers whole. But the idea that you would take that remedy away permanently, so what would the remedy be? There are no fines under the law. You can't put anybody back to work because no one's been fired. So really the only remedy is to restore the work to its original location. And you know, again, and this of course would have implications well beyond the Boeing situation. Now, as far as the board's membership, I mean, when Craig Becker was nominated, Craig Becker, who had been an attorney for SCIU and part-time for the AFL-CIO, you would think that President Obama was putting Karl Marx on the NLRB. I mean, how often have Republican presidents chosen employer-side attorneys? Almost routinely, they come from the employer side. But the idea that a union side attorney would be put on the board was, oh my God, my hair's on fire. We've got to stop this. And so I just think that was a ridiculous overreaction. And we're going to see that again. There probably won't be anybody confirmed from now on. I don't see that. I don't see how how any future nominee of the board is going to be confirmed, which is a tragedy. We're going to have a non-functioning board pretty soon. Now, as far as the, I'll close with this, with the election rule that's been referred to, the proposed rule. Again, this idea, this ambush election, you know, I'm sorry, we don't see it that way. In about half the cases where ULPs are filed, they're filed for pre-election for activity or conduct that took place during the pre-certification period. Employers know when a union, when workers are talking about forming a union, they know almost the first day. And by the way, the worker has no access, as you know, to the work. The union has no access to the workplace, so it's not exactly a level playing field. As I said, the employer can hold captive audience meetings, one-on-one meetings, as many as they want. They can, by the way, they can fire you if you refuse to go. Now, if you think, you know, this quicker election is unfair, if you want to sit down and talk to us about giving the union access to the employees, that we might agree to a longer time period and actually have a debate like in politics, where both sides have equal access to the voters. Neither side can make threats, but that's, of course, not the way the real world works. So the board's proposal here, I think, makes a lot of sense, is to try to shorten that period. After the petition is filed, the employer has every opportunity to make its views known from the day they hire the employee. And the union has, as I said, a pretty tough time meeting the employer's campaign head on, because they've got to find them out in the parking lot, or they got to, you know, find out where they live. And by the way, you know, they don't get the addresses of where they live until the last minute. So it's a pretty tough situation for workers, for unions who want to try to organize. So that's pretty much the way we see the world. Finally, on campaign finance, Eugene talked a little bit about campaign finance. He mentioned the $400 million that the union spent. Well, business spent about $2 billion. So it's a little hard to, if you only look at one side of the equation, it's not a total picture. We think Citizens United ought to be, it ought to be overturned. What's happening in our politics now is it's the furthest thing from, we think, from a real democracy. We'd like to see public financing of elections when the Koch brothers and others like them can spend hundreds of millions of dollars undisclosed. And this Disclose Act, by the way, we were perfectly happy to have our presidents, if they make donations from our union treasuries, to run ads on the ad themselves saying that they paid for the ad. Disclosure is fine with us. I don't know why it's not fine for the business community. So we do need to fix our elections. And the final thing about Ohio, because somebody mentioned Ohio, is it does seem that the governor of Ohio may have gone too far. Looking at the polls, as you know, where the SB 5 went down almost 2 to 1, and interestingly, 57% of independents voted to repeal SB 5. Among the white working class, non-college educated, 61% voted against SB 5. Kasich had won that group by 14%. So I think there is something happening, and I think people are going to resist this overreaching by Republican governors and in Congress. And obviously we won't know for sure until next November, but that would be my prediction.
First of all, do we have any comment that any of the panelists want to make in response to each other?
Yes, but I'll defer.
This is your opportunity before we open it up for questions.
Yeah, I'll just, if my mic's on.
Can you hear him? Yes.
Yeah, just briefly on a couple things that Bill mentioned. During the Employee Free Choice Act debate, it always interested me that the period of the 50s, 60s, and 70s was identified as this golden era for the American worker, union and business alike. Because when you drill down and take a look at the situation then, you realize, especially in the industries that were being held out as the great examples, that there was an unsustainable bargain at the heart of it. So you often hear, for example, of the auto industry as the paramount example of the grand compact that had been reached between unions and business, but it was not sustainable. The other thing that's notable about that era is the not just the frequency, but almost the incessant nature of sizable labor disruptions. So at the big three through the 50s and 60s, almost every contract renewal, at least one of the big three was struck. Even though President Truman opposed the so-called Taft-Hartley injunction power, he vetoed the Taft-Hartley Act, he nonetheless then proceeded to enjoin and call several national emergency strike injunctions against strikes in the ports and elsewhere. Eisenhower used it repeatedly, so you had many national emergency injunctions through the 50s, 60s, and early 70s. We don't have them anymore. We have a very different environment, and I don't think the American people today would be comfortable going back to the kind of incessant labor disruptions that were a staple of the American economy during the so-called heyday. Just final observation, I speak in my personal capacity, not in the capacity that I also hold as Boeing's counsel in the board case, but I don't think that case is routine at all. I think it is appropriate that people are highly alarmed by it, and it relates in a sense to my first point. It should come as no surprise that a company, in planning for the future, considers, among other things, the likelihood that it will be struck. That is a natural and appropriate thing to consider, and it's quite frightening to American business that leaders in government believe that a company has to act oblivious toward the possibility of being struck in the future. That's contrary to Supreme Court precedent, and I think it's a very troubling case that was brought.
Can I?
Yeah, sure.
Yeah, I would just say a couple of things. One, we should let the trier of fact decide whether, in fact, those statements were retaliatory. We're still at the fact-finding stage here, and some have rushed to Congress to change the law. It seems like we ought to let a complaint's been filed. The general counsel said with those sets of facts, he's been there 30 years. He didn't feel he could find it any other way, but we are still very early in this case. If Eugene is right, and that was, in fact, does not amount to retaliation, that's what will be found. And we ought to let the trier of fact and the ALJ and then the board decide that. As far as, well, about the 50s, 60s, and 70s, there was a reference made to industrial strikes, and the like. And, sure, democracy involves trade-offs. We don't have strikes now. Instead, we have huge income disparities and wage stagnation over the past 30 years. I'm not saying that everything about the prior decades was preferable to the current decades, but I do think that if you give the Americans the choice, my guess is they would probably choose higher wages and benefits and put up with some disruptions. And I would finally say about Detroit, I mean, I really get tired of hearing about this bargain that brought down Detroit. What made Detroit uncompetitive was the car designs, which the union members don't decide on. It wasn't the size of the pensions or the health care benefits. It was cars that nobody was buying. Now, Detroit has fixed that problem, thank God. They're now building cars that people are buying. It was not the guy on the shop floor or woman on the shop floor that was killing Ford or GM in the 1970s. It was the designer who was deciding what kind of car to make and what kind of fuel economy to put into that car.
Well, I think you're wrong, but I'm not going to try to defend the Etzel.
Okay. Yeah. John?
Just a couple of quick comments. Unions are winning.
Put the mic up.
Pardon? Oh.
Pull the mic up.
Unions are winning, I think it's something like over 60% of the elections. On the Boeing strike, it's quite interesting to delve into the particulars, because when Boeing first looked into the North Charleston area, it bought a company to help create the new location, and it was IAM represented, and then at one point they're decertified. And for some reason, this Boeing tussle came after that. I wonder what prompted it. And then, in terms of commentary, unions have the right to strike. Companies have the right to lock out or hire permanent replacements or what have you. I mean, you've gone on strike multiple times over the past 15, 20 years. We have contracts with other countries and other companies around the world. We have to deliver on time. We have to know that we can deliver. Our whole manufacturing operation is unionized here, and if you keep this up, we're going to have to go somewhere else.
If you keep this up, what was the up? Keep what up?
If you can't sit down and we can't work out a bargaining agreement, yeah, I think it's perfectly fine. I don't see that they committed any, but anyway, I'm not on the board.
Let's entertain some questions from the floor, and let's make sure though that your questions. This isn't an opportunity for speeches. It's time for questions.
Yes, I'm Samuel Wright with the Service Members Law Center. There have been 850,000 National Guard and Reserve members mobilized since September 11th. In a number of instances, we've had mobilized employees in Iraq, in Afghanistan, when the NLRB is conducting a representation election. NLRB says we don't do absentee ballots. I know of an instance in Pennsylvania, Union 112 to 11, there were 2 service members in Iraq who did not get the opportunity to vote. They could have affected the outcome. But I think that the NLRB ought to provide for an opportunity for service members who've been mobilized and are, unless they get killed, are going to be coming back, are going to be affected by this election to vote. And I'm also opposed, for the very same reason, to the quickie election. That's inconsistent with providing the opportunity for an absentee ballot. I hope Mr. Samuel might support the rights of those who are in the workforce but temporarily away because of military service for our country.
Thank you for that question. Do you have anything you want to say?
It sounds like something to consider. I don't know the history of the board's decision on that, but it certainly sounds fair to people who are serving our country that they not be excluded from the ability to make a decision like that.
Next.
First, Mr. Samuel, thank you very much for coming. I was very struck by your comments about the distribution of wealth in the United States, as well as your allusion to the international situation. Now, as you know, in the international situation, usually the paragon of good distribution and high labor rights is, of course, Western Europe. And there they don't have that problem with a bad distribution of wealth, they do have one other pesky little problem, which is that almost all of the governments are bankrupt. And that's because they have promised benefits to the population that they can't provide, very much as some of the states, individual state governments here have. And I wonder if what is going on in Western Europe, which is an implosion of that system, very similar to what happened at General Motors, with a lot of focus on rigid labor markets, which don't allow the kind of labor productivity that's necessary to support the debts those governments have, does that give you pause at all? And I'm sure the answer will be no, but as you know, rhetorical questions are not illegal at the Federalist Society.
Does it give me, okay, I'll say yes, it gives me pause. I don't know. Listen, I think the international economic crisis is extremely complicated. I don't pretend to understand international banking. I would be very hesitant to blame it on pensions or the number of workers who belong to unions in any country. It seems like we've had high union density in many of these countries for decades. Now, all of a sudden, since the crash of 2008, all these countries are in trouble for reasons that I would suspect don't have very much to do with the number of public employees. Now, that may be something that looks like a good solution. It's something they can get their hands on and do something about rather than re-regulating banks. But I'm not sure that that's the cause.
This question is for Mr. Samuel. If I recall, you had said, you know, if possible, the AFL-CIO would love to see Citizens United either repealed or in some way mitigated. But as I recall, the AFL-CIO had filed an amicus brief in favor of Citizens United. Is there some sort of buyer's remorse about the decision, or why exactly is the AFL-CIO suddenly opposed to it?
Yeah, my recollection, I didn't work on the brief, is that we had a particular issue with the way they were not distinguishing between corporations and unions in the way the case was brought to the court. It was not that we were looking to overturn the decision. So I don't think you're right about that if you go back and look at our brief.
Anybody else?
Is there an important distinction between collective bargaining in the private sector versus the public sector? It seems that if the current function of a union, for example, is to improve wage conditions and benefits, at a time where you have restricted budgets on state levels and that sort of thing, collected action seems to be problematic for a state entity in a way that it may or may not be as problematic for a private entity. That's for all of you.
Well, I'll take an initial swing at that. I think there are some very important differences. I mean, the idea behind labor protections is that employers may take advantage of workers such that we need the government to step in and establish some level relationship there. In the context of public sector bargaining, the employer that might be misbehaving is in fact the government. So right there's a significant difference. I think we're far less likely to fear or have reason to believe that a governmental entity is going to be so rapacious towards its employees than a profit-making private employer. Beyond that, there are, as I mentioned, some very serious concerns with the incentives that government officials will feel to give lavish pay and benefits to union members, which the members and their union can in turn use to fund that person's reelection, which is really, I think, the cycle that developed in the States. And although, as I remarked, I think this dispute obviously is not settled. You had significant changes in New Jersey and Wisconsin, for example, Indiana. Now there's been a bit of a retrenchment in Ohio. I expect we'll see much more development in this area in 2012. If I were the AFL, in some ways I might be focusing more on that even than in some of the federal elections. But I think there are a lot of reasons to distinguish those circumstances, and I recall reading, I think Amity Schley's had a piece on it at the time, that some of your great labor leaders of the 40s and 50s thought that public sector bargaining was a very bad thing, anathema to the idea of a labor movement.
You want to say?
Yeah, I mean, I think it gets to sort of a fundamental question of whether workers should be able to get together, have a collective voice over any number of subjects. You know, if you go to Ohio and look at some of the issues there, they have to do with whether firefighters are able to bargain over safety equipment, the number of men or women on a rig. I mean, things that are really critical to them that without some system, which is collective bargaining, where they can sit down as equals and bargain over these things. Again, I think Republican opponents, some of the governors and legislators who came in 2010, I think were very successful in making it seem like somehow public pensions were something that they had and you didn't, and it's because the system it doesn't work. In fact, shouldn't we have a race to the top rather than a race to the bottom? Shouldn't we try to promote the idea of defined benefit pension plans instead of looking at the last group that has them and say they shouldn't have them because you don't? I mean, we don't think very much of politicians if we don't think they can sit across the table and bargain on behalf of their communities because they're just looking for a campaign contribution. I mean, most of the times it works.
There is quite a good case example. If you go online and check the Chicago Tribune or the Chicago Sun-Times on a daily basis,
the pensions?
It is very helpful to understand why the public sector model needs some serious renovation for the reasons that Gene mentioned, frankly. It's very difficult to think that there's going to be any kind of control when you've got that relationship between the individual on the other side of the table being funded by the people on the other side of the table on the hopes that returns will come back.
A genuine and short question for Mr. Samuel and Mr. Raudabaugh. Is it the case that it's as important today as it was in the late 1940s to have a legal regime that forces labor and management to be adversaries? That is, for example, that would prohibit a labor union from providing payroll and accounting services to an employer, or prohibit a labor union without involvement in a joint labor management trust from providing apprenticeship and training services to an employer. And if it's not, shouldn't we lower that wall somewhat in order to cause labor and management to look more to their common interests and less to regarding each other as, the opposite party in a court divorce?
I think there's no question about it, and that's sort of the thesis here of this article. The fact of the matter is, I can't accept this notion that there's just this one pyramidal type, and you either go for that, which is rife with what I've always called adult student counsel. You know who the class president is, of course. And you either have that, or you have no voice mechanism that legally allows you in the private sector to sit and discuss issues of interest with the employer. Alternatively, I also think you could have a model where you would have essentially your high school student council president, but it would only be of that high school where you work. Doesn't necessarily have to be upstream to some of the known oligarchs here in Washington. Who, when I talk with union councils that have been around as long as I have, it is overwhelming to hear their comments. At the end of the day, you know what the real problem is? We're all people. We know what other people, we know what human beings are like. And what I'm suggesting is people don't necessarily have to pay to have a representative from their group at that location and form their own little group. We need to have a legal system that allows an expansion along a spectrum of options to then go about the process of discussion, and reaching some kind of commonplace doesn't mean it has to be a battle. And I think what exemplifies American labor history is it is a very antagonistic approach. And I'm not suggesting that from those few years at Cornell that I bought into win-win and all of that stuff. But I am suggesting that not everyone even wants a combative relationship at their workplace.
Okay.
You know?
I just say very quickly, I think the way people view 8A2 as somehow a bar to employees discussing with their employers all kinds of issues, one-on-one or in small groups, I think is way overstated. I mean, 8A2 has a historical reason for its existence. Companies seem to want to form these little groups in ways that really look like bargaining, only they wanted to choose their representatives. They wanted to decide what the topics of discussion would be, when and how they met. That's a company union. That's what 8A2 prohibits, not discussion about quality or safety or any sort of individual or small group discussion workers want to have with their employers. I think the bar to that is way overstated by the.
Well, I have some familiarity with electromation, and what it precludes would be discussion with their employers over mandatory subjects of bargaining. You couldn't have a wage analysis committee to make recommendations on what the structure should be for next year. Sorry. Sorry.
Last question.
Thank you. This program should not conclude without hearing the panel members' comment. This is going to radically change the practice of law firms if it goes through. Many law firms will no longer be able to practice in this area. This is very serious, and I'd like to hear the panel.
Well, I certainly take it personally. and you know, it was quite a proposed rule. In the preamble, the Labor Department said that lawyers were ubiquitous and deleterious. So I was offended by that too. But look, it's part of a piece. You know, the intent.
You should take pride in that.
The intent is to make it harder for employers to anticipate and respond in a variety of ways, and one of them is to make it a bit harder to obtain counsel, and that's disturbing in part because you'd think that the government would want employers to be well counseled. Lawyers in those circumstances are ordinarily saying, here's what you need to do, here's what the law requires. Employers that are uncounseled in those circumstances are probably going to make more mistakes and violate the law more often.
The fact that this came within a day of what the board did on the notice of proposed rulemaking, the fact that the notice language for implementing the presidential executive order of notice employee rights for government contractors, all of this to suggest that there is no electronic connectivity or human trafficking between the independent agency, the National Labor Relations Board, and the Department of Labor is just unbelievable. The idea that they're going down that road lends new meaning to. I remember under this administration when the OSHA department first announced all their new crackdown and they came out, it was plan, protect, prevent. And I think it's actually an additional P, and punish. The issue here is to deprive people of an opportunity for counsel. What is counsel? What is advice? Obviously, there's blending and so forth. And yes, there are some law firms that we know that are heavily weighted towards campaign diatribes and that kind of thing, as opposed to others where the labor representation is far removed from that. But the fact of the matter is, what's going on, it's so obvious, so terribly, terribly obvious. It goes back again to this issue of keep the employer quiet. The same thing with the under EFCA. If you could do the card check and all of that and keep it under the cover, my response to you is simply, you want to come and have an equal response to, if I were an employer, I would love to invite you to respond to my captive audience speech, have equal time, and then I want to go to the same trips that you take everybody out to some bar, restaurant, or club and buy drinks and free pizza and invite me too. But let's not overlook how these campaigns go on, okay?
If I'm not mistaken, the persuader rule is it's a disclosure requirement. Firms are already required to disclose under some circumstances. What they've done here is, I think, eliminate or close the advice loophole so that a law firm can't produce all of the material, have the employer send it out, and act like that was advice and not be filing a disclosure report. It's hard to, I mean, you said you're going to deprive companies of getting legal advice. I don't see how filing a disclosure report, which is going to end up somewhere in the Labor Department, is going to deprive companies from doing that. But it seems like it would be useful for people to know what's, who's doing what in an organizing campaign, just as the union has to disclose.
If the employer's counsel reviews and revises a piece of a
Please speak
campaign-
into the microphone.
Pardon?
I couldn't hear you.
If the employer's counsel reviews and makes a single change in a piece of campaign material, the law firm will be required to disclose all of the fees received from all of its clients for any type of labor relations services for that entire fiscal year. Now, if that doesn't realistically prevent the law firm from providing the advice, I don't know what would.
Will you please join me in giving a round of applause to our panel?